Hey, everybody. Thank you so much for joining me. And I really hope that you can hear me today. We have been having some Wi Fi issues out here in Europe. But nonetheless, I am here for another conversation with you. And I'm super excited because I have something I want to offer you guys. It's going to be going down this Saturday. So, super excited about that. Again, welcome back. My name is Attorney Sylvania DeBarros. I am the founder and CEO of the S.L. DeBarros Law Firm. So at this firm, we represent athletes, million-dollar brands, entrepreneurs, creators, who are all in this thrust to create something long term. So we typically say legacy, right? A lot of people drop the word legacy. But in order for you to have one, you have to protect what you're creating. And one of the ways that you can do that is through contract enforcement. So today, what I want to share with you guys is around the topic about what most million-dollar brands don't know about enforcing contracts until it's too late. So I've said before many of times, people have this myth that just because some people are running what seems to be very successful companies or organizations, and they're pulling in multi-7, multi-8 millions, 8 figures, which are millions of dollars, they think that everything is going according to plan. And it is not. It is not. All right. Not always. So a lot of you guys know that I've worked with speakers, athletes, CEOs who are pulling in these high dollar figures. And I can tell you that when things get dicey, it's not the money that they have that protects them. All right. The money didn't protect them when the contract got ignored. The money didn't protect them when somebody walked off and said that they weren't going to pay what they knew they were obligated to pay according to that contract. The money that they're making and pulling into their company doesn't do anything. It doesn't protect them when an employee goes rampant. All right. So it's not about how much money you're pulling in. It's about what you do with those contracts that you have. Right. So this conversation is not for you if you don't even have a contract, if you're not interested in getting one. It's not for you if you are not at that $1 million level or interested in ascending your business to that level. Okay. So in order for you to enforce something, you have to have done the foundational work, which is creating that contract, closing that deal properly. So I have a question for you guys. What's the actual plan if somebody does not honor the deal? What's the plan? Because this is what I see as a huge issue in a lot of deals that go south, those deals that go wrong, that create a lot of headache and aggravation at the end of the day. There was no plan. So we're going to talk about that. We're going to dive into that today. And I want to share 5 big gaps that I see in these high dollar contracts, because these are the mistakes that $1 million brands are making about enforcing their contracts. All right. So let's jump into this. And if you want information, before I go into the 5 big gaps, if you want information on enforcing your contracts, then what I would suggest is that you get my free download. And I don't know why I'm saying that I cannot post in the comments, but get my free download. You can go to bit.ly, get paid on time, all caps. So bit.ly/get paid on time. And you'll be able to download my free resource that walks you through the same system that I go through with my clients to enforce their contracts. Okay. So this is also going to show you guys, I'm sitting outside. So the bees and everybody is out here. But what was I saying? So this blueprint walks you through that step-by-step process that I use to help my clients enforce their deals. And it also gives you language that you could use. This doesn't cost you anything. If you know you're missing something in your business, it would behoove you to go ahead and download this free resource so that you can start filling in those gaps for where you are. All right. So let's jump back into it. 5 big gaps that I see in high dollar contracts. All right. Number 1, vague language. vague enforcement language. You don't mention at all the consequences or the timelines that need to be abide by. If it's not in writing, it did not happen. The last thing that you want to get yourself into is a he, she said match. And now you're digging, trying to figure out where was the communication that I had with this person before we signed the contract. And sometimes you are so excited to engage in this deal that you sign the contract, and then you make certain or place certain parameters supposedly around this deal after that deal has been signed. That's not good. That is not good. There's too much vagueness. There's no enforcement, or the enforcement is very bare bones. People don't really know when they're supposed to deliver certain things, or when they're supposed to pay certain things. Or maybe you said that this company was going to pay, let's say, $5 million at the end of the contract, but your understanding was that you would be paid portions of that $5 million along the way. But even if you're saying, okay, you're going to pay me $5 million at the end of the contract, what is the end of the contract? Is it the end in terms of the end date, or is it when all of the services have been delivered? Because services could have been delivered, or products could have been delivered before the actual date that a contract is set to terminate. Does that make sense? All right. So think about that. Escalation. How would things be? How would things be enforced? And timelines. What are the timelines that you're really looking at? And make sure that you take a step back, take it to your counsel, have them review it, so that if there is any vagueness that is a part of your deal, you can address those issues earlier on before the deal is executed. Okay. A second big gap is not having an escalation path. All right. And this is what this blueprint will definitely help you to cultivate, is what that escalation or enforcement will look like. So when your deal goes south, what is the next step? A lot of companies and high-level entrepreneurs do not have an escalation path. Nonetheless, they don't even have an attorney that they can escalate this to. A lot of businesses are working with brand lawyers, if you will, but they don't have anyone with that litigation experience on their team. And that could be a problem. Okay. So you need to have a plan of how you're going to escalate this enforcement. So if you follow the steps in the blueprint and they still don't respond, what is the next step? Who is your lawyer that's going to step in and help you to try and mitigate your losses, but help you to go to the next level if necessary? And the next level sometimes means you may have to file a case. All right. Gap number 3. All right. Gap number 3. Huge. A lot of people miss governing law and jurisdiction. And sometimes they think of it as the same thing. And so they just group it together. Oh, well, the jurisdiction is going to be, let's just say, California, but you operate out of Florida and the other party operates, let's say they're in Arkansas. All right, just to throw something out there. But your jurisdiction is California. First off, what is it about California that appeases you? Or is this something that you found from a template? Because if you have to escalate to enforce your contract, meaning that you have to go all the way in court, now the state that you don't reside in, the state that you potentially don't even do business in, is the state that has jurisdiction. So that's where you have to file that case. That's where you're going to have to find litigation counsel, right? So it's going to cost you more to go to another state that you have no relationship with, that your deal is not even connected to. So you really, really want to think about that. But also the governing law piece. Governing law and jurisdiction is not the same thing. You can decide for one state to have certain jurisdiction over your deal. And at the same time, you can decide that although we're going to agree to resolve whatever our issues are in state A. I want to apply state B's law. Now, we call this choice of law provision. And sometimes individuals choose this because maybe that particular governing law is a little bit more favorable based on what their deals are. I'll tell you, I prefer that my clients choose Illinois as their governing law. One, that's my primary bar state. But in order to file a claim on written contracts, you have a longer period of time to file that claim versus other states that, 4 years? Okay, 4 years to bring a suit. 4 years can go by extremely fast. So you really want to think about what your choice of law and your jurisdiction will be. And I know it sounds boring, but it can cost you a fortune, because when you start trying to play outside your zone, it costs money. You got to go and find counsel. If you want your current counsel to join them, they have to also file a motion. I've done this plenty of times for my clients where I've showed up in out-of-state forums and I've had to file motions asking that Supreme Court to give me an opportunity to practice law there. But I also have to make sure Okay, I'm back. Sorry about that, guys. I told you before I started, we've been having some Wi-Fi issues. So hopefully you've been able to hear this live so far. But as I was saying, choice of law and jurisdiction sounds like it's boring, but it can be extremely expensive. And what I was explaining was I have gone and appeared in different states that I was not barred in because I had to seek permission from that Supreme Court of that state in order to practice there. But in addition, I had to find counsel who was barred there. And so it may cost you more. Obviously, litigation is going to cost you more anyways. But you really want to think about how long could this case potentially go on for. If I decide to go into a different jurisdiction, those fees in terms of attorney's fees may be completely different. Let's just say California versus a Florida lawyer is going to be different than what you may be used to paying. So pay some attention to that contract. Pay some attention to that contract. Just don't sign it just to sign it. And definitely don't have a contract that is missing this language, because that could cost you big in financial dollars. Okay, it can cost you big in the financial sense. Okay, so let's jump over to the fourth big gap. Not having clarity on ownership of IP, content, or performance obligations. This is huge. If you are a speaker, raise your hand. If you are a content creator, raise your hand. If you are someone who creates or designs apparel, shoes, anything, this is huge. This is huge. And I think because creating comes so easy to a lot of entrepreneurs that they don't think about safeguarding it inside of their deal. So you need to take a step back and clarify who owns what. If you're coming in and you're creating a joint venture straight off rip, you need to clarify who owns what. If you are creating the soles of a shoe or you're designing logos, whatever the case may be, you need to figure out, is this something that I am working on obviously jointly for this joint venture, but if we decided to walk away, who actually owns this piece of the IP, right? Who owns the name? Who can take the name? Did you come into this joint venture with the name? Okay, well then if you did, that's your IP. So you want to clarify that even if this relationship splits, if we decide to go our separate ways, I'm going to take my IP that I've created, that I brought to this partnership. Certain content, a lot of people write content and they have no contract in terms of what they own. Right? You can tell people, like if you're a content creator and that contract ends, your contract can pretty much say at the end of this relationship, if you decide that you no longer want to work with me or you want to cut this contract, then maybe you can license that content to them for it to sit on their platform for however long, and they pay you a certain amount of money, or they have to change that content or take it down altogether. Performance obligations. People don't even talk about this. So you guys have to really think about, what are you bringing to the table? What is, let me back up for a second, because I think a lot of times when I say IP, I'm talking about intellectual property. When we think up or we conjure up certain ideas and we get to the point where we've executed these things, we don't necessarily attach a dollar figure to it, because sometimes those ideas have not yet yielded dollars, but it does not mean that it has no value. So that's why it's important that you clarify who owns what. And so in my clients' contracts, when we're dealing with IP, I actually draft up an addendum that shows the IP that they have created and that they're creating over time. And that should be something that is consistently updated so that there is full transparency in that relationship around the ownership of intellectual property. All right. So let's jump to the fifth big gap. This is huge, y'all. Nobody ever trains these multimillionaires or these multi-dollar brands. Nobody ever trains them on how to use the contract. They just sign it. And you guys see this all the time. We see singers and actors. I mean, people who literally have household names end up in the media over bad deals. Over bad deals. They don't even understand their own deal. So I don't want you to be that person. I don't want you to be that brand. I don't want you to be that entrepreneur, that CEO. When you sign, before you even sign a contract, the first thing that you should be doing is asking your counsel about that language. This is why when people come to me and they say, hey, I want you to review my contract. Okay, I can review it, but what is that going to do? We must have a sit down in a meeting for you to understand what is it that you want out of this deal. And more importantly, what do you think you're getting out of it? Because most of the time, and I've seen this a lot, most of the time that people think that they're getting out of a deal is not what they're getting out of the deal based on the black and white that I see in front of me. But then the next necessary part is to explain what I'm seeing. Explain the issues that are there. Explain the gaps that don't serve their interest. So you don't want to just have a contract and sign. You also need to have your lawyer express to you, explain to you, this is what this contract is. This is what this language means. This is how you use this contract. This is how you can enforce this contract. All right. And that should be built into your operations. If you clearly understand your contract and if you have an escalation plan and you know how to enforce your contract, this would be such an easy part of your business, because your lawyer then will be there to step in at the best time possible to help you to mitigate and resolve these legal issues surrounding your contract. All right. All right. So again, I'm going to tell you guys, go ahead and download the contract enforcement blueprint, which is Get Paid on Time, because this is going to give you an insight and steps to help you enforce your own contract. Right. So you can get that at bit.ly/get paid on time, all caps, get paid on time, bit.ly/get paid on time. And I wish that I could type it in here, but for some reason, it's not allowing me to do that. Now, if you are one of these $1 million brands, you are a CEO who is doing high level deals, maybe you want to go a little bit deeper. You're not just trying to fix one contract, but you're trying to build an actual enforcement strategy. So I am offering a small group VIP session, which is part education, but also part legal war room, if you will. But what I do want to break down for you guys is that it's not a generic Q&A. This is about walking away with a clear plan, a clear strategy, and learning from others who are in the room with you, who are dealing with the same thing. All right, so here's some things that I want to highlight for you. One, this is a group setting. This is not a one-on-one because I'm keeping the costs low compared to what I typically charge for a VIP session, which is $2,500 is my normal rate. So I'm keeping this very, very low. And I'm going to tell you guys what that investment is in a little bit. But this is a group setting, and it's only limited to high-level entrepreneurs. All right. And then the first 3 people to register, you're going to get a free private consult with me to go even deeper. One reason why I'm offering this is because I know sometimes people have certain things that they want to share confidentially. And this VIP room will not be confidential. We're going to be diving into certain contract aspects to help you to enforce and create a plan for your business so that you can safeguard the legacy that you're creating. All right. But if you are one of those 3 people to book your VIP session first, you will get that private consult. So if there are certain things that you want to say to me in confidence, this is where you would be able to do that. So as I said, the value for the VIP session is $2,500, but you're getting it for $495. Literally, y'all. I mean, it's a steal. It is a steal. So if you want to be in this room, I'm only taking 5 people. After 5 people register, that is it, because I have to keep this room small so that we can go as deep as necessary. All right. So that you can really walk away with a true plan. So 1, don't forget to download your free contract enforcement blueprint, which is at bit.ly/getpaidOnTime, all caps. Make sure you download that first. And second, go ahead and book your VIP strategy session. Again, limited seats, limited to 5 people only. And you can see the link here at bit.ly/VIP-no legal drama. And it is case sensitive, so you need to write it exactly the way that I have it. bit.ly/VIP-no legal drama. All right. So I hope that this has been helpful for you guys. I really don't want you to become this multi-millionaire, $1 million brand and don't even know certain things about enforcing your contracts before it's too late. We don't want to make millions of dollars just to give it away for free. Okay. So let's do what we need to do now on the front end to build in those safeguards. I am Sylvania DeBarros, and again, I hope that this has been helpful for you. Until next time, guys, I'll see you later. Ciao.